Today we're continuing the Associa Gulf Coast Educational Series. Today we're going to talk some legal scenarios. Most importantly, or directly, we're talking about emotional support animals and service animals. What are they? What's the difference? And what to do about it. Our featured speaker today is Attorney Drew Corbin from Rabin, Parker, Gurley here in the Tampa area. And Drew, welcome to the show. Really appreciate your time. If I could you kind of introduce not only yourself, but a little bit about how you got into the law and everything we need to know about Rabin, Parker, Gurley.
Well, thanks, Paul. I am with Rabin, Parker, Gurley. We practice exclusively community association law. I developed a little bit of a specialty as it relates to fair housing issues, particularly emotional support animals and service animals. So I handle a lot of the accommodation requests that come through our firm. Like I said, we practice exclusively community association law. It's all we do. We just represent associations.
Since it's your niche, if you will, you're the perfect guy to talk to. As you know, we're full disclosure, we're talking in early or middle of November 2020, which is we're still in the COVID-19 world, if you will, with potential lockdowns and stay-at-home orders and all that. So the educational series so far has been extremely well received, but most importantly, the idea behind the educational series is to ensure that managers, board members, and unit owners, quite frankly, get better information about stuff that, quite frankly, we don't know and we're not good at, quite frankly, when it comes to certain legal issues. Now, full disclosure, I'm not an attorney. I don't play one on TV. That's why you are, and that's why you're here. But emotional support animals and service animals is certainly a topic that is big right now here in Southwest Florida. And I can make the assumption it's big everywhere right now because in today's society, we live in that litigious world where everybody's offended about a lot of different things. Everybody's sensitivity is on high alert. And we want to make sure that the confusion behind emotional support animals and service animals, we want to lessen that confusion and give you, the board member, or you, the manager, better information because you've got questions. It's not just as simple as, something popped up from a unit owner and let's just call the attorney. We still need to know the basics, the foundation about emotional support animals. So that being said, Drew, there's a couple of scenarios that pop up immediately, but before we get into those scenarios, what is the legal definition and then your interpretation, if you will, of what is a service animal and then what's an emotional support animal? And quite frankly, what's the difference between the two?
Well, there's definitely a difference between the two. They're two distinct accommodations under the Fair Housing Act, both broadly referred to as assistance animals. A service animal is an animal that has actually been trained to alleviate the disability. So this is your seeing eye dog. A blind individual has a dog that has actually been trained to help the individual navigate. A deaf individual has a dog that's trained to alert the individual when the doorbell's ring or rung, that kind of thing. So the dog has to actually be trained to alleviate the disability. That's a service animal. 9 times out of 10, it's going to be a dog. There is an exception for a miniature horse, but typically a service animal is going to be a dog. An emotional support animal, on the other hand, can be any animal, and it does not require any specific training, but just alleviates the disability therapeutically, if you will, by nature of being a friendly animal. So the key difference is that an emotional support animal can be any animal, and it doesn't require any training, while a service animal does, and it's usually going to be a dog.
Right. So I'm going to use the phrase from the layperson like me, when we see out and about in public, a golden retriever that's wearing that, and the golden retriever could be any kind of a dog, but is wearing that vest that says service animal in work, please do not touch. That's a trained animal for a specific purpose versus the concept of, and you hear these things on the news where, it's an emotional support squirrel or something like that. I mean, from the simplicity of it, that's a fair way to explain it. If the service animal is going to be a trained animal with the vest, it's going to be very obvious it's there for a purpose. But an emotional support animal, like to your point, could be anything. That's fair, correct?
Correct.
Okay. Now, a different piece of this puzzle that comes up what seems like all the time in associations, and whether it's condos and HOAs, it's going to be handled a little bit differently, but unbelievably very similar, is the requirements that associations have or potentially have regarding the acceptance of a service animal. So if we just stay on the service animal side of this, again, that trained animal for a specific disability, if I'm a unit owner and I need a service animal, or I have a service animal and I have all the paperwork, but the association, for whatever reason, is considered a no pet association, are there any limitations or any, for lack of a better phrase, are there any concessions given to me as the unit owner who's got this need when I submit to the board? Can the board deny me as with a service animal request?
Well, no, and that's really the crux of the Fair Housing Act. Is the Fair Housing Act requires housing providers, as a community associations, really anyone involved in the furnishing of housing, to change a rule or policy when that's necessary to afford you an equal opportunity to use and enjoy the premises. So, that's the poster child kind of scenario that you have, where a community association doesn't allow dogs, an individual needs a dog to alleviate their disability or assist in their disability in some way. The Fair Housing Act is going to require the association to allow the dog onto the premises so long as the individual can show, with medical documentation that they need the animal. So that's really the crux of it, is that the Fair Housing Act requires an association that would otherwise be able to prevent the dog from being on the premises to have to allow the dog.
Now, you bring up a really good point, though, because that is going to be different than the emotional support animal, right? Because by definition, that could be anything, like a squirrel, so to speak. But same question, but different variable, which is, if I'm the unit owner and I all of a sudden I want an emotional support cat, can the association deny that request? And we're only talking general speaking, obviously. We're not looking at a specific association.
Yeah, generally speaking, they're not going to be able to deny the request. Now, assuming that the individual has reasonable documentation from a medical provider, which a medical provider could be a doctor, a nurse, social worker. The definition is so broad. They have medical documentation from a medical provider that reasonably supports that they need the dog. The association is going to have to allow it. Now, what does reasonably supports mean? What kind of documentation do you actually have to have? Well, I can tell you for sure that the online certificates and registrations that you see from, serviceanimal.org are not sufficient, and the Housing and Urban Development Department of Housing and Urban Development has made it clear that that's not sufficient. What you're really looking for is a letter from a medical provider that shows they have personal knowledge, shows that they actually have some form of professional relationship with the individual, such that they are able to opine on whether the individual needs the animal. If you have that, the association is pretty much required under the Fair Housing Act to allow the animal in order to forego any potential discrimination liability.
Okay, you bring up paperwork, which is, I hate to say it, in today's world, there's paperwork for just about everything. But the concept of paperwork or needs, if you will, to validate that need. Now, you're talking about the requirement from a healthcare provider, a nurse, a doctor, a social worker. If the governing documents for an association effectively are silent in any of that stuff, just silent in general, let's just say it's a no pet facility or no pet association, so there's nothing about pets other than you can't have them. From a legal perspective, what would be your opinion as to what should the association do to amend their documents to include certain documentation that would be required to handle this type of a situation? Could you speak a little bit to what would you suggest associations consider when they're going to update their documents to address the emotional support or even the service animal issue?
Well, we recommend at the very least that boards adopt a resolution prescribing their procedure of how they handle accommodation requests, support animal accommodation requests, things like that. You'd want to have things in there like how much time is a person going to have to submit the request? How much time is the association going to have to review the request? What kind of restrictions are you going to put in there? That kind of thing. And every association is different. So, for example, I've seen a restriction where an association that has a shared laundry facility will not allow laundry that has come into contact with a service or support animal to be used in that laundry facility. A highly risky provision, if you ask me. But every association is different. That's an area where they've taken a stand. I think they have a number of residents that have allergies to animals. So every association is different, but at the very least, you want to have some kind of procedure in place as to how the requests are going to be handled, how much time is going to be given to both parties, any kind of restrictions that you would want to put in there with the caveat that you can only provide reasonable restrictions. You can't do something that's not going to allow the individual to have equal use and enjoyment of the premises. So you can't say, you can't limit where they're going to go, things like that. You couldn't require them to have to keep their dog in a crate, things like that. So anything unreasonable is going to be risky in the context of discrimination liability. But yeah, we usually recommend that associations at the very least adopt a resolution that kind of outlines what the procedure is going to be when an accommodation request is made.
Understood. So using the example of the laundry room that you talk about, and again, every association is different. We're not talking about any specific associations at all. But if an association has two separate laundry facilities on premise, the assumption could be, or the accommodation could be, that because of the perceived allergies from other unit owners, that the board could direct the unit owner with the service animal or the emotional support animal that if they're going to bring that into a laundry room, they could use laundry room A, but not use laundry room B. Is that kind of how I'm understanding that? Just from the 5,000-foot view, you're still making the accommodation, but you're also taking into consideration other unit owners' concerns.
Right. Well, the point I was trying to make is that different associations make different decisions after being apprised of all the risks that are in play. One association may decide to put that restriction in place, while another association may decide not to. The elephant in the room is that there's six-figure potential discrimination liability at stake if you're kind of pushing the limit as to what is reasonable and what is not. The other kind of kicker to all of this is that everything is reviewed on a case-by-case basis, and none of these specific situations that kind of come up in these discussions are directly addressed by the Fair Housing Act. So what we're having to do is we're taking the language from the Fair Housing Act and trying to apply it using the guidance from the Department of Housing and Urban Development and using case law that's developed around this area to try to make inferences as to how it might go. But it's always reviewed on a case-by-case basis, and there's no hard and fast answers to a lot of these questions. So, you just go back to the broad language of the Fair Housing Act.
Right. And I think you bring up a really good point in that there is no hard and fast, black and white, this is going to be the answer. Everything is going to be construed on a case-by-case basis. But as you said earlier, these could be 5, 6, 7-figure discrimination challenges to associations if they decide to kind of quote unquote take the matter into their own hands. We, as Associa Gulf Coast and as a managing agent, we don't practice law. We're not attorneys. Managers are not attorneys. Quite frankly, that's why associations hire attorneys in this example. But really, where I'm going is it fair to say that regardless of the experience of the manager, regardless of the experience of the board in this type of a scenario, if and or when an emotional support animal or a service animal issue rears its head to the association for any type of a decision, is it fair to say that the association should pretty much contact their attorney as soon as possible to get that layer of understanding and that interpretation started so that the board can make the best decision on behalf of the association?
Yeah, I think so. I mean, even if it's just to have the attorney review the documentation that's been provided, it's just really crucial in this area, especially because there's all kinds of arguments that can be made in terms of, hey, you're not applying your restrictions consistently. You only allowed, or you allowed this individual to bring their emotional support animal onto the premises, and they supplied this documentation. I supplied even greater documentation, and you asked me to provide more, or you haven't granted my accommodation request. So it's crucial to at least allow legal counsel to take a look at the documentation to kind of guide on a big picture how the association should be handling the requests. The biggest thing that we talk about in our office is called the interactive process. And the interactive process is a requirement under the Fair Housing Act that both parties at least make a good faith effort to come to some kind of solution before ever denying a request or retracting an accommodation that's already been made. So, for example, let's just say an individual submits emotional support animal documentation, and the documentation is insufficient in some way. So, for example, maybe the doctor didn't sign it, or he referred to the individual incorrectly, maybe he used the wrong name or the wrong birthday or something like that. And so there may be a temptation for the association to deny the request just based off the documentation that they received. But the interactive process will not allow that to happen. What the interactive process requires is that the association go back to the individual and say, hey, look, here's where the documentation is insufficient. Here's what the Fair Housing Act requires. Here's a reasonable amount of time to kind of make the corrections and resubmit the documentation. Just to say, just to kind of help community associations in dealing with these issues, it's really crucial to remember the interactive process and always get legal counsel involved.
So you bring up a good point about timing, and let's put this in real world terms. Where here it is today, November 19th, and literally today, I buy a unit in Happy Valley HOA or Happy Valley Condominium Association, and I walk in with my service animal, let's say it's an emotional support animal. I walk in with my emotional support cat, and I have paperwork, and I hand it to the manager, or maybe I hand it to a board member, depending on the environment. How much time, because I already have the cat, right? I'm literally moving into my home right then and there. How much time is reasonable for the association to review and make a decision, or at least inform me, the unit owner or the buyer, if you will, of what's going on? And the reason I ask this is there might be a gap of the board might not meet for another month, right, to make any formal decisions, or the board might need to get to the attorney to review documents, but the cat is already there. So is there any sort of understanding of how much time is reasonable for a decision to be made or information to be conveyed to that unit owner or the buyer?
Well, I think, it's better to be safe than to be sorry. And what I mean by that is it's better to forego doing anything drastic and avoid the risk of discrimination liability. So the Housing and Urban Development Guidance says that you have a reasonable amount of time. So what that means is anyone's guess. There has been case law that's supported that if an association does not respond to an accommodation request within a reasonable amount of time, they can be deemed to have constructively denied the accommodation request and could be subject to discrimination liability. The other kind of factor in play is that an association can take reasonable steps to enforce their pet restrictions up until documentation has been supplied. Now, I would read that to mean after a reasonable opportunity has been provided. So you show up to the association with your cat and your documentation. I would say as a best practice, the association should respond within at least 10 days. And if it gets into a situation where your documentation is insufficient and the association has provided you a reasonable amount of time to supply the documentation and also maybe, multiple opportunities to supply the documentation, then the association arguably could deny the request because they provided that time.
Okay. So if we continue just down that thread, the idea of the unit owner with the emotional support cat has supplied some documentation, board has reviewed that documentation, and let's just say, again, a week, 10 days, let's just call it reasonable to be 10 days, just for fun for this discussion. In 10 days, the board comes back and says the paperwork is inadequate, or they went and, they saw the, emotionalsupportanimal.com, website that they got, and they paid their $20 and they got this certificate. And the board, after talking to the attorney, denies that request. Well, now the situation is, what steps can the association take to effectively remove the animal?
Kind of going back to the interactive process, they really shouldn't deny the request at that point. What they should do is go back to the applicant and help, describe why the documentation is insufficient, and then supply a reasonable opportunity for it to be corrected. Now, assuming they do all that, and the request is ultimately denied, and they're seeking to remove the animal, they may try and file injunctive relief, or move for injunctive relief to have the animal removed. A lot of times it will get kicked to the Office of Human Rights that handles a lot of the discrimination claims. So, it's difficult to say. They're going to be looking for injunctive relief, the association, but the other party could kick it to the Office of Human Rights and kind of bring it into a context of, hey, I'm being discriminated against because my dog isn't being allowed on the premises, or my cat.
Right. It's going to open up a whole, in my mind, it's going to open up a whole another can of worms. So generally speaking, with that example, is, quite frankly, for the board members that are listening, let the law and let the attorneys play it out. Don't circumvent things. Don't deny right out of the gate. Literally communicate with the attorneys, get your association counsel involved, and let the legal course play out. If for no other reason, and it's not about cost, because associations will be fearful of, oh my gosh, this is going to cost so much money. It's not about the cost. You want to let this play out so that it is not only is it done properly, but you then could potentially remove litigation issues down the road if you, as the association, jumps the gun to make a decision. Am I kind of understanding that from a 5,000-foot view? Is that fair?
Yeah, that's exactly right. And, with the Fair Housing Act, it's structured in such a way that it's so favorable to the disabled party, which of course is natural with the kind of legislation that it is. But, that's something that the association should keep in mind, is that this law is not really there to help me. It's not going to do me any favors. And so, really the association should be, treading carefully, making sure legal counsel is involved, and not doing anything drastic, without consulting legal counsel.
Right. And the reason I bring that up is because I've been asked these questions. I've sat in board meetings where these questions have been asked. But the reason I bring it up is association boards, they want to make decisions. They want to deal with it and be done. And from a management perspective, we want to make sure that it's done, but it's done properly. And that means, in this example, attorneys, and that means the legal process. And I totally agree with you. Let's let the process play out. Even though it might take a lot longer than the association wants, or the Mr. or Mrs. Smith of the association who's complaining about that cat in this example, again, letting the process play out will save the association time and headache, and certainly money over the course of time, for lack of a better phrase. But bringing back to paperwork and responsibilities and those types of things, when an association has put in guidelines about what paperwork they could require in their governing documents about these types of requests, again, health opinions or healthcare provider opinions, those types of things, that does not absolve the pet owner, if you will, whether it's an emotional support animal or a service animal, the responsibility of maintaining the health and the activity level of that animal. What I mean by that is, let's use a dog in this example. Well, dogs, when they go outside, they need to relieve themselves. So even though it's an emotional support animal or a service animal, the owner still does need to take care of that animal, correct? They can't absolve themselves of, say, picking up the doggy poo, for lack of a better phrase, just because it's a service animal or a sport animal. They're still responsible completely for that dog, even if that dog bit another dog or another person. That's the right way to look at it. The owner is still responsible 100% for that animal, regardless of if it's an emotional support animal or a service animal, correct?
Correct. And the key word out of the Fair Housing Act, the language in the Fair Housing Act is reasonable. So the accommodation has to be reasonable, and that's kind of the ammunition that's provided to the association to say you still have to pick up after your dog. Your dog can't be barking, causing a nuisance to other residents, interfering with their rights, and your dog can't pose a threat, obviously, to the health and safety of the community. But again, not to beat a dead horse, but I would just go back to the interactive process and just say, for example, if you had a dog, an emotional support animal in the community that was demonstrating a dangerous disposition to other people, maybe it's lunging at other people, or maybe it's even bitten somebody, the association needs to at least consider in good faith alternatives that could be put in place to kind of alleviate the danger that's posed before just going to the individual and saying the dog has to go. Now, do they actually have to implement those alternatives? I would say no, but they do at least need to consider them. So, for example, maybe putting a muzzle on the dog, having some kind of protocol in place where the dog is not going to have interaction with other residents, that kind of thing. The association has to at least consider it before seeking the animal's removal under the theory that it's a danger.
So it totally makes sense. And again, this entire topic can be emotional, no pun intended, but it can be frustrating. It can be unbelievably confusing. And the reason I say that is, and again, this is going to sound weird talking to an attorney about this, but if we ask 10 attorneys to interpret this scenario, there's a real good chance we're not going to get, just one answer. There's a real good chance we're going to get 6, 7, 8 different, 9, maybe even 10 different interpretations of what is reasonable, what is required, those types of things. The end result is, for the managers out there and for the board members out there that are listening, the end result is literally, when this issue comes up, and it will come up in your association if it hasn't already, is get the attorneys involved. Because even if you are an attorney on the board, if you're no disrespect to divorce attorneys, but if you're a divorce attorney and you're the board treasurer, well, that doesn't mean that you understand community association law. That does not mean you understand fair housing law, like you're talking about, Drew. And the idea is, again, to engage the proper professionals to alleviate the headache, not only immediate headache, but the long-term headache for the association. So the end result is always, from our perspective, is get the attorneys involved. I feel in the meetings that I've sat in and the board members that I've talked to, is that they naturally don't want to go to the attorneys because of cost. But let's be realistic, Drew. It makes no sense to be worrying about a $200 or $300 legal opinion to follow the Better Business Judgment rule, that you as the board are doing what you can in engaging the proper professionals depending on the issue in front of you, as opposed to ignoring going to the association council and just trying to deal with it on your own. You're opening up a huge can of worms. So that's a fair way to look at this. When in doubt, consult the attorney.
Yes, and I think to your point about there being different 10 attorneys having 10 different interpretations. I think that's just really just a byproduct of the law. And this year we've seen many different entities from HUD, Housing and Urban Development, to the Florida legislature come out with laws and guidance that kind of help the interpretation of the Fair Housing Act. So I think as time goes on, it'll be easier to understand the framework of the law. But consulting with legal counsel is crucial, obviously, just for the practical advantage, but also just for the fact that you said the business judgment rule. It's going to help bolster that defense if you've consulted with legal counsel. If you ever get into a situation where you're facing liability for a decision that you've made as a board member, it's going to help you if you've consulted legal counsel before making that decision. And yeah, our firm has seen damages for discrimination in the emotional support animal context reach six-figure amounts. So it's a realistic threat. It's a real risk that associations are facing. A few $100s for good legal advice is really just a drop in the bucket when you consider what could potentially occur a discrimination claim was ever to be alleged.
Right. And don't get me wrong, we're trying to swing that pendulum and describe the really bad situations. Not all of them are this bad, right? But from the perspective of the educational component with Associa Gulf Coast, we at the very minimum want to say this is how bad it could get. And we want to be real and objective about what could happen to associations. So Drew, you've given us a lot of information to think about, and don't get me wrong, we could talk hours about emotional support animals and really dig into the weeds about the minutia of the law. That we're going to save that for a later day. But for those individuals who are listening to this, they might not be looking at the screen right now. What's the best way for a unit owner or a board member or even a property manager, whether they're working with Associa Gulf Coast or not? What's the best way to reach out to you directly to maybe kind of pick your brain a little bit more about this topic?
Well, of course, you can always reach me by email. My email is drewdrew@rpglaw.com. You can also call me. My number is 727-314-7639.
Outstanding. Well, Drew, again, really do appreciate your time. Much continued success, not only for you, for your law career, but also Rabin Parker Gurley. You have worked with and continue to work with several of our clients here in the Associa Gulf Coast market. We speak very, very, very highly of you and your firm. Again, much continued success for you, and thank you very much for your time today.
Thank you so much for having me.